Yurii, here is a technical issue. In case for some reasons the interview is interrupted, suppose there is air alarm or there is no electricity or internet connection, the Commission will definitely reach you. Please keep your mobile phone close to you. We will continue our interview, starting with the place where we stopped, on some other day at some other time. Please try to give your concise answers to the core of the matter, and the member of the Commission asking the question may limit you as far as the duration of your answering is concerned. Before we start the interview, you will have a chance to spend 5 minutes on telling about your motivation, the basic things, the ideas, why you and why exactly you should be appointed a member of the High Qualification Commission of Judges of Ukraine. So let us start the interview, and let me give the floor to my colleagues. Colleagues, you're welcome.
Good morning, Mr. Bodnaruk. Are you comfortable and well there? Can we hear you?
Yes, I can see you, I can hear you, okay. Everything is fine.
Very good. You have now the floor for, let's say, an introduction. Sorry? Can you hear me?
Yes, Robert, I can hear you perfectly well.
Okay, fantastic. You have now the floor for, let's say, a short introduction. I also would like you to introduce yourself so that the people who are viewing what we are doing also know who they have in front of them. So if you could introduce yourself and explain to the audience who you are, why you are applying, and what your motivation is to participate. For the rest of the interview, I would request you to be concise in your answers. The experience of yesterday is that people tend to give extremely long answers on questions, and in general we would say that to give concise answers is a lot better, because then we are able to have discussions about more subjects than only limited subjects, and we can get a better view of who you are and what your ideas are. Please go ahead.
Once again, I would like to express my gratitude, dear members of the Commission. I'm happy to be here with you. Thank you for the opportunity provided to me to participate in the second stage of the selection process. According to the rules of procedure, let me tell in brief about myself and about my vision of the role of the HQCJ in the future of the Ukrainian judiciary. My work record in the field of law is a comprehensive work record. For 15 years, I worked as a scientist and a lecturer in one of the leading law institutions, which is Odessa Law Academy. Now it's university. The field of my scientific and research interests and the area of my lecturing includes financial and tax law. In 2008, I presented my PhD thesis and got the degree of a PhD. That was the first basic research, fundamental research related to procedural regulation of the mechanism of enforcement of tax commitments. And in fact, this research led down the foundation for the Ukrainian theory of tax proceedings. Then in 2012, I got the degree of the rank of the associate professor. And also at the university, upon the assignment of my department, I had to prepare a draft scientific opinion for the state authorities, the Constitutional, the Supreme Court, and I researched some complex problems in the field of application of financial legislation. I was also interested in practical activity. I used to work at companies, at a law firm, and I also had some managing positions. And I majorly dealt with the representation of the interests of people in courts of different instances and specializations. I had to work with contracts. I had to accompany interaction of people with self-government authorities and state authorities. I would say that I had some cases and tasks that were really interesting and responsible. I mean, these were some tax disputes, commercial disputes, civil disputes, labor, inheritance law disputes. And in 2009, I got the certificate to legal practice and I could start being a practicing lawyer, and I could protect and defend people even in criminal cases. Let me tell you that in 2012, I also got some experience of participating in the selection as a candidate for the judicial position, and on the basis of the results of the qualification assessment, I was included to the staff reserve, but as far as participation in some competition for filling the vacancies is concerned, it was not a success.
You have only 5 minutes, huh? I wish to remind you.
Good, thank you. So in 2019, I decided to participate in the HQCJ selection for vacancies of the appellate courts, and I submitted the respective documents. Knowing about this intention, the judge of the newly established High Anti-Corruption Court invited me to work as assistant judge in his office, and I agreed because back then I really needed additional skills to know how to compile draft court decisions, and I wanted to know how this is done and what the role of the judge of the appellate instance is in this respect, and how this is generally done and what this mechanism looks like from the inside. So over the recent 3 years, I've been working in the appellate chamber of the High Anti-Corruption Court, and for me, that has been a very good experience, an example of impartial, independent, and fair justice. The justice, the way it should be, professional, efficient, and quick. And just let me tell a couple of words about my motivation for the participation in this competition. The point is that I really think that the previous compositions of the HQCJ did quite a lot of useful things related to the implementation of selection procedures, their improvement, gradual improvement. But unfortunately, many candidates, experts, and the society still had some questions concerning the results of the selection, the fairness of the selection process. So my motivation is to actually restore the trust of the future candidates in the HQCJ as an institution, and to do my best to really fill the Ukrainian judiciary with new judges who are people of integrity. Thank you for your attention.
Thank you very much, Mr.
I'm sorry, if I still have some time, I could tell about my vision. No.
No, I think you're there. We will come to your vision, no doubt, Mr. Bodnaruk. And the first question I have is that when I looked at your autobiography and your motivation letter, I noted that you are, let's say, your background is tax administrative lawyer, and you have become a associate professor, and then you changed to become, let's say, an assistant judge, which is not so long ago, it's 2019. So you have been working as a assistant judge in the High Anti-Corruption Court now for 3 years, I guess. And after these 3 years, you are trying to become a member of one of the highest institutions of the judiciary, which is again a change of job, because then you will not be a judge or assistant judge, but you will be a selector. Is this not a bit much in a very short period to change from a tax financial lawyer practitioner into someone who is in a high office in the judiciary? And it looks as if you have quite, let's say, a drive to come into a really prestigious position. What do you say about that?
Thank you, Robert, for the question. Well, partially, I gave the answer to the question during my introduction speech. The point is that my current work in the anti-corruption court as assistant judge was actually caused and was planned as some interim, temporary job due to the fact that I submitted the documents and decided to participate in the selection for the vacancy of in the Court of Appellate instance. And I wanted to learn how it works from the inside before that, and what the judge of the appellate court should be doing. So this experience was supposed to be temporary, but in 2019, the HQCJ stopped operating, and that's why these competitions were stopped, were terminated, and unfortunately there has been a long break in those competitions. But as far as the prestigious job is concerned, I really fully realize what my level of responsibility would be if I take this position. I fully realize this, but I would say that my motivation is not just my personal motivation. It's not about personal motives only. I really want to join in the judicial reform and to make my positive contribution into that. Thank you.
Okay. What you say is that you want to be part of the reform, so you believe reform is necessary. Can you please explain why you believe reform is necessary and what you will be suggesting that the reform will be? So what is it what you will do when you will be elected in the HQCJ? And I would request you to answer within the 3 minutes.
Thank you, Robert. Thank you for the question. The point is that this is not only about my vision that the reform is required. That is the vision of the society, of public experts, of the legislators, because you know that the legislators stopped the mandate of the former composition of the HQCJ and has changed the selection procedure. So what is the essence of the reforms? I would say that the novelties, about 20 laws that have been adopted by the Verkhovna Rada, and you know about the amendments made into the law on the judiciary and status of judges. And all these amendments actually set the ground for the new model, but this model needs to be filled. We know that the HQCJ has also some norm-making, law-making mandate, so partially it has to regulate the issues that are put to its discretion, which are mainly the issues of defining the methodology, the mechanisms of assessment, the criteria of assessing candidates.
Of course, we know, of course, how the laws work. What I'm asking is, what is your view on the present situation in the judiciary and why you believe that this should be changed? Because you just said that you wanted to be a part of it because you believe in the change. And that means that you have a view about the present situation in the judiciary and you also have a view about the change. Maybe think about that.
Thank you. So what kind of changes are these? First of all, there is an urgent need to complete the steps which were started by the previous composition of the HQCJ about the purification and renewal of the authorities of the judiciary, which means that the new composition of the HQCJ must complete all selection procedures, start qualification assessment. And what is the essence of the reform? The essence of the reform lies in the fact that the HQCJ should, first of all, change the approaches to all those procedures, make these procedures really transparent and not just to the outside, in terms of its appearance, because the appearance was rather good even before. Its task is to make assessment of candidates really fair at all the stages of the selection or the qualification assessment. I've also got my vision concerning each of those issues, if I may.
Well, maybe a bit later, because then it will take a bit of long. We will get there, don't worry. In your motivation letter, you refer to a book called Radical Honesty. You recall that? Yes?
Right.
This book is about how to transform your life by telling the truth. So when I saw that you were referring to this book, I was considering, why is this reference done? Are you someone who are always telling the truth? And if you do, is it sensible to always tell the truth? Or is it allowed sometimes to lie? Or is it not allowed to lie? We say in English, a white lie. There's quite some research that people during the day say things that may not be true completely. And they do that because of it's polite or it is nice or you don't want to offend someone. But the book Radical Honesty says there's only one way of living, and that is never, ever to lie, which is, I find, quite dangerous. But if you say that, it means that if I ask you a question, you always and fully will have to tell the truth. So I'm really interested how you look at that.
Thank you for the question. You're absolutely right. The point is that it doesn't mean that I fully share absolutely all the statements made by the author of this book, but for me it is important that when we build personal relationship with your peers, with your colleagues, relatives, it's important to tell the truth. And this will help a person stay in harmony with oneself and not create additional tension when you have to all the time build some structures on lies, recall what you have said before, and this will create some tension for you. But really, you're right about saying that there may be situations of white lies when you have to tell the lies on a forced basis because you don't want to offend the person. I mean, that sometimes we need to select words.
Okay. And is this also, let's say, related to the reference you made to the inevitability of karma? You referred in your letter, you say, in life I try to act according to my conscience and on the basis of my believing in the inevitability of karma. I believe that karma and the inevitability of karma are two different things. Inevitability of karma goes much further than that. It believes that good action will lead to a good rebirth in a pleasant human situation, and bad action doesn't. If I think about that and you apply to a high position, the HQCJ, and you believe in the inevitability of karma, I'm wondering whether such a belief would lead to change, because you would, let's say, have the idea that anything will happen because it is karma and not because you put in lots of effort yourself. Can you please share your views?
Well, first of all, I would like to thank you for such a detailed and scrupulous attention to my motivation letter. As far as karma and my vision of karma is concerned, I think that any good deeds, any actions taken by a person in harmony with a conscience, maybe not in the nearest future, but in further prospects, will anyway be remunerated for with good things. And when well, I can tell this about myself, that I think that if you can do something good, if you can give help to someone, you don't have to wait for some immediate remuneration from this person. This remuneration will come, but it'll come later. Anyway, due to some accidents and occasional things. As far as the fact that this does not depend on the person, the point is that fatalism and karma are different things, as for me. And the belief that nothing depends on you is fatalism. It's not about karma, as for me. Thank you.
Okay, I will shift now to Mr. President.
Пане Юрію,
Yes, thank you, Robert. So, Yuri,
філософських висот пропоную спуститися.
let's move down from philosophy to our sinful earth. And again, let's refer to your motivation letter.
Трошки
I've got interested in a little bit different aspect of your motivation letter that you covered. You claim that you can tell it from your own experience of qualification assessments for judicial positions, and from other sources you have some idea about certain unfair practices which were actually the opportunity for them was let down in the very procedure and in the organizational aspects.
і так далі. Ви можете, будь ласка,
So could you please decode
а що саме
what exactly was let down? What kind of opportunity was let down in the procedure and in the organizational selection procedures? As far as I understand, if we remove what has been let down there, these bad practices, unfair practices will just disappear or not. If you could tell this, because you claim that you have your own experience in this respect. Yes, thank you for the question. Well, first of all, I've had some experience of undergoing this qualification assessment after anonymous testing. And every participant, every candidate is preparing a draft court decision in all specializations like administrative, civil, criminal cases. And these works were done manually, by hand. And when a candidate, and me in particular, got the score for each of those draft decisions, how could I appeal? Every candidate has access only to his own papers. And we don't have access to the papers of all the other candidates. And this means that the procedure is not transparent. Therefore, when I appeal the score, it's kind of difficult. Now, the law partially has changed the procedure in the sense that the result of the assessment can be reconsidered and revised by the plenary composition of the HQCJ, which means that you can make an appeal and the appeal will be considered. But again, there is no opportunity to compare your paper with the paper of some other candidates. Okay, let me ask clarifying questions. So do you think that lack of access to the papers of other candidates means unfair practice? Well, I would say it's not transparent practice. If we have an alien observer, a lawyer, an expert, and he cannot compare two papers and the score given for them, I would say that this is not that much transparent. And that is a certain resource for manipulations. And if there are 300 candidates at the same time, 300, 500, 400 candidates, from the practical point of view, would it be really good to have access and to all of them and to compare all of them? It could take months. Well, but if an alien observer is willing to do this, so why shouldn't he be given access to such papers? Okay, I do understand what you mean. What other unfair practices could you mention?
процедура та організація конкурсів.
The procedure itself and the organization of the competition. Well, if we talk about competition to fill in vacant positions, so every candidate was supposed to submit an application to be part of the competition, to be appointed at one judge, at one court. So the High Qualifications Commission, and as far as I know, from talking to other contestants, there was this opportunity potential unfair practice, because it was a kind of a lottery for all of the candidates. You cannot guess what kind of demand will each court have. So you don't know what your chances are when applying. Plus, based on the results of such a competition, it may turn out that the candidate who were lucky enough to guess what the demand is going to be will be appointed with lower points. So it means that they may be less competent, they will not be people of integrity, and people who are more competent, but solely for the fact that they did not guess what the demand is going to be, will not be appointed. And just a clarification as we go, do you believe that you can have more or less integrity as a person? Well, in the methodologies that have already been approved by the previous HQCJ, the criteria could be mathematically calculated. If something can be calculated or assessed mathematically, then we may assume that somebody can have more integrity than the other candidates. Well, of course, it's up for the Commission to decide. But during the previous competitions, we didn't even have any indicators, any criteria of ethical and moral values. But again, here it's at the discretion of HQCJ and a source of manipulation. Do you believe that we can calculate integrity using some mathematical formulas? Yes, that's what the previous HQCJ thought. Well, I know about them, but what about you personally? I think that you're asking me quite a difficult question. It's my job to ask these questions. Yes, but still, thank you for the question. There are different approaches here. Some specialists believe that it's necessary to break down every criteria into smaller components and rank them and have different points assigned to all of those components depending on the type of competition that we are having. And there is a different opinion, which I probably support more, is that we need to decide whether there's reasonable doubt about the integrity of a candidate or whether it's not there. So there are two approaches here. Thank you for your answer. I don't have any more questions. Sorry, colleagues, that I took a lot of your time, and I'm passing the floor to Mr. Mezintsev.
It will be my pleasure.
Good morning, Yuri. My last name is Mezintsev. I'm the co-rapporteur for your interview, and judging from the questions of my colleagues, I think you're maybe having some doubts about having this detailed of a motivational letter, but we will not be focusing on your motivational letter anymore. As a co-rapporteur, I would like to talk a little bit more about your career in 2008. You presented your candidate thesis. You did that at your alma mater, at the Odessa Academy of Law, which is currently a university. You used to be a lawyer, a legal counsel, and judging from the responses of your students, you were a good lecturer and you had quite a good professional level as a lecturer. You've been an associate professor for 11 years and a teaching assistant at the department. And having this wide of a background and this high level of competence in the sphere of tax law in particular, in 2019 you decided to make a drastic career change. You decided to change your specialization. As a lawyer, I know how difficult it is, and you decided to switch to criminal law and criminal procedure. It's a completely different area, different field of law. It's completely different from tax law, and it has its own specifics. That's why I'm having this question for you. You've explained a little bit. And the judge that you are working for, Dmytro Mikhailenko, in his reference letter for you has also explained that you have some kind of professional relationship and also personal relationship, and he invited you to work at the High Anti-Corruption Court after he was appointed the judge. It's quite understandable and it explains a lot of things, but still, you had a successful career as an academic and a successful career as a lawyer, and you decided to swap it for the career of assistant judge. If we look at the hierarchy of professions, it's downshifting. I'm also a court of appellate court. I have an assistant judge working for me. He's been with me for many years. I consider this person to be my colleague, not an assistant, because I trust him completely. But solely from the financial point of view, a successful career of an academic and a lawyer, again, has been swapped for the career of assistant judge. And I do know that the salary of an assistant judge is not that high as we would like for it to be. Do you consider this to be downshifting in the financial respect, first of all? And how do you overcome any financial issues, should you have them? Thank you very much for this question, Mr. Mezentsev. As far as the financial status is concerned, it wasn't downshifting for me, and you can trace this in my declarations. Yes, that's clear. As far as the prestigiousness of the position is concerned, I have already explained this. The thing is that I was planning to have this position temporarily. Yes, you were trying to gain some experience to be later appointed a judge at the same court, because I wanted to participate in the competition to be appointed a judge of appellate court. We also assess our candidates under the criteria of political neutrality. And from the documents that you've submitted, we see that you were involved in some political events. So you were a member of the election commission, you were working for one of the candidates, but you didn't mention who it was specifically. We'd like to get to know who that person was, and you also participated in the elections. So whose interests were you representing, or were you a candidate yourself, and what political party were you representing? Thank you, Mr. Mezentsev. My experience of participating in the elections is quite episodic, as I mentioned in my motivational letter. So the first occasion, that was back in 2010 or 2011, I was a representative, an authorized person of my former partner, and he was running to be appointed an MP of the Odessa City Council, and he required some legal counseling, but he was not elected. And in 2000, let me find the date, and in 2019, I was part of the elections process during the extraordinary elections to the parliament. I was member of the elections commission. And according to the openly available data, I could not find what political party I was representing. But let me tell you that this was quite a responsible position. We had one of the biggest voting polls. There were 20 people that I managed, so it was kind of a managerial experience for me. The elections were fair, transparent. We didn't have any complaints filed against us. And I even have a copy of the final protocol of the elections. As a judge of the administrative court, I realize what the head of a polling station should be doing of the elections commissions, and I know that quite often lawyers are being appointed because they can manage the others quite effectively. You have quite a structured, logical view of things as a lawyer. And these things are necessary to fill out all the documents. You also mentioned that you would do everything so that to ensure that the future candidate judges perceive the competition for HQCJ as fair. So let's not focus on the words that you will do your best, because these are very general words and they are quite empty. But please tell us about 2 specific measures that you would like to implement in the future procedures of HQCJ should you be appointed as its member. And please explain why you would like to implement these specific measures. Thank you for the question. 2 specific measures. Well, the first one will be improvement of the selection procedures that the HQCJ is responsible for. That includes the selection itself, the qualification assessment of judges during different procedures. And number 2, the second measure that I consider to be necessary, that is to make predictable, fair, and just decisions. Well, Yurii, this is your duty to work according to the procedure established, to be fair, transparent, and lawful in your work. But please be specific. Could you name any specific measure? The increase of the number of tests, for instance, the introduction of a polygraph test. And if you support this, explain why. Maybe some other specific procedures for the selection. So do you have any specific vision? Maybe let's not focus on 2 specific examples, but can you please come up with one suggestion that could improve the work of HQCJ and create the impression that people indeed are knowledgeable about what they are doing and they are trying to do their job in the best way possible to select others in a fair way? Well, thank you. Now I understand your question. Well, it was already discussed yesterday, and this question is being raised today again, the shortening of the duration of selection, because selecting people for 1.5 years, for 2 years, that's too long. Plus, a lot can change in the country, the composition of the committee can change, of the commission can change. How can we do that? Well, first of all, by introducing specific training in between the selection testing and qualification assessment. The thing is that currently the state ensures special training for qualified lawyers who have applied. So we are using the budget funds to train these people, and in the end, the majority of these people who are trained at the expense of the state for 12 months, these people, the majority of them will not become judges. It doesn't make any sense. We need to shorten this period of special training as much as we can, so that the applicants are focused more on their tasks, like the drafting of court decisions or maybe dealing with specific case studies. So, for instance, there might be a specific task that they have to deal with. Well, I've gotten your answer. I understand what you are trying to tell us, what kind of procedures you are trying to make shorter. Let me please finish my thought. If there are any specific explanations that you'd like to introduce, let me just finish with this idea. So, after the qualification exam has taken place and people have been named part of the reserve, then they should be trained at the National School of Judges so that they are prepared for their future work. They should be taught how the court hearing looks like, how different typical cases should be considered. Well, thank you.
Роберта, я буду передавати слово іншим.
If Robert allows me, I will pass the floor to the other commissioners.
Mr. Bodnaruk, thank you for your participation in the competition. In reading your motivation letter, you say that in order to restore trust in the future candidates of the High Qualification Commission, we need to make sure that we're differentiating between those individuals who satisfy what you call as the high standards of the competition, but are not simply imitating such compliance. Of course, you're right about that. None of us wants candidates who are imitating compliance. But how exactly do we ensure this? How exactly should the new High Qualification Commission ensure this? How would you, as a member of the High Qualification Commission, ensure this? How does this commission know that you're not simply imitating compliance? How do we know that our next 60 candidates are not simply imitating compliance? How do we make that differentiation? Can you offer us some counsel in that pursuit?
Thank you, Stephen, for this question. Well, first of all, in my motivational letter, I was telling about imitation, not by the candidates, but the HQCJ, about the selection done by HQCJ, that the selection is fair and transparent. I was talking about this kind of imitation by HQCJ, but I do understand your question, meeting the integrity criteria, for example. It's a difficult question about the integrity criteria. It's debatable. And I think step by step, academia and practice are moving towards finding the answer to this question. But I do believe that we already have some serious work done by the Public Council of Integrity. It can be found on their website. They have elaborated a number of indicators that tell us about a candidate that is non-compliant. I do believe that this list of indicators is quite good. Maybe they could be improved, but they are based on the effective legislation and on the practice, on the practical experience of civil society organizations have gotten by analyzing the work of active judges. So there are some questions, there are some serious complaints there, and there are many indicators on the list. And I think that we can base our work on these indicators.
So you think there may be some scientific or algorithmic ways by which we can determine actual compliance with our standards as opposed to artificial or imitative compliance?
Do you mean a scientific approach in terms of psychological testing? So we currently...
I was referring to the reports that you had mentioned that you thought would assist in this process.
Well, the things that could assist us would be to learn from the experience of other countries that are applying such criteria in their practice while selecting their judges. Not just the experience of the other countries, but also learning from the experience of Ukraine, because we already have some findings from the Public Council of Integrity, and this could become the foundation that can be improved with time. Thank
Do
you.
you agree that the involvement of the three international commissioners that we have on the selection commission may be helpful in providing some illustrations of the experience in judicial selection in their home countries?
Yes, sure. This is the international experience that I was talking about. You are the renowned experts. You, the commissioners, as well as members of the Ethics Council, of course, it could be useful.
Reading the letters of recommendation on your behalf, Mr. Bodnaruk, they're very good letters of recommendation, and you have some good friends and supporters. But they all seem to be in agreement that you are principally a very good legal theorist. Is that what the High Qualifications Commission most needs in your judgment? Or should we be focused instead upon people who have more practical and direct legal experience with the judicial system?
Thank you, Stephen. Well, my reference letters don't only mention me as a theoretician. You're talking about the reference letter provided by the professor and head of the department. The other people who have provided reference letters for me, they were focusing on my practical experience as well. And I'd like to draw your attention to the reference letter provided by the judge of the appellate chamber of the High Anti-Corruption Court, Dmytro Mikhailenko. And I believe that my experience of practical work is quite relevant and versatile, because I've participated as a lawyer in different court hearings, in courts of different specializations, in commercial courts, administrative courts, criminal courts. So I've had this experience, and I'm gaining new experience at my current position.
Okay, thank you very much.
Good morning, Yuri. My name is Serhiy Varlanov. Good morning, Serhiy. I will change the topic of our questions a little bit. While studying your documents, the Commission has come up with the question about your property, the property that you have declared. So I would like to provide further context, and then I will ask you my question. So, as seen from the documents, in 2016 you bought an apartment, a two-bedroom apartment in the city of Odessa. From your declaration for 2017, we can see that you declared an object of incomplete construction with the area of 75 square meters. And then in your declaration for 2021, you mentioned that on December the 16th of 2020, you already registered the right of ownership to an apartment in the city of Odessa. And regardless of the fact that it was mortgaged that you used to buy this apartment, but in your declarations for 2017 through 2019, you did not declare any payments that you've made under this mortgage with respect to this apartment. So my first question is, could you please explain this non-declaration of your financial obligations under mortgage? And number two, can you please explain how this investment that was considered to be non-residential property back in 2016 was registered by you as a two-bedroom apartment, which is residential property? You're welcome. Do you understand the question? We cannot hear you. Yuri, could you please wait for a moment? Can you hear me now? Yes, I'm sorry. Maybe you have to speak closer to the mic. Yes, I do understand your question, and let me explain. As far as the payment for the apartment is concerned and lack of information on any financial obligations in the declaration, so I've just checked that. This type of payment, it wasn't a mortgage, let me explain. It was the procedure of making payments. I was making payments in installments. I didn't take out a mortgage. I was not supposed to declare that. So this is not a financial obligation. Because the installments in which I was supposed to pay for the apartment, I have paid them in full by 2020. And I have provided the commission with the documents. And there is this extract from the State Registry of Rights to Real Estate. And it's mentioned in this extract how I was able to register this apartment, and it becomes clear that in 2017 I've already made the payments. So as far as the status of this property is concerned, non-residential or residential, the thing is that the premises complies with all the sanitary norms. And you know that there is this practice of the developers when they make the final floor and assign it with the status of a non-residential property so that they can somehow overcome these limits with a number of stories. And these apartments are usually sold at a lower price. That's why I decided to buy it. At the time, I was staying in Odessa, and I didn't have time to re-register, to change the status. So I was working with lawyers who were helping me with that. And they registered the right of ownership in my name, and the status changed to an object of residential property already. So there were different technical inspections. Well, I understand your answer. I don't have any other questions. Thank you.
Yes, Mr. Bodnaruk, my name is Ted Zazechny, and I'm a member of the Selection Commission. There was a very active discussion that you have had so far with respect to some of your ideas respecting changes in the HQCJ process that would contribute to its operating more efficiently on the one hand, and to gather and gain more public trust and confidence. One of the areas you were invited to discuss dealt with the concerns that both candidates and the public may have about the level of discretion that currently exists with the HQCJ selection process. Some critics have suggested that that can introduce outside influences. Now, they have suggested that one of the solutions would be the scoring of all aspects of the HQCJ assessment process, so that there would be, in effect, very little, if any, discretion left, that everything would be scored. The examinations, the practical exercises, the psychological testing, all of which is now scored, but as well integrity. There are others who say that part of this process should continue to involve an element of discretion and judgment. And that in particular applies to the area of integrity. What is your view in terms of whether or not you would favor changes in the HQCJ process to score all elements of its investigation and judgment of candidates? Or, on the other hand, if there is some discretion to remain and judgment to be exercised, in what area?
Thank you, Mr. Zarzeczny. Well, we should be looking at the law, first of all. We should be looking at what the mandate of HQCJ is, how the HQCJ should assess the candidates. So we are assessing professional competence, individual competence, social competence, as well as integrity and professional ethics. So this is the requirement of the law, and it's completely fair. But the question about discretion is the following. Regardless of the approach that we choose, the HQCJ members that decide on a specific candidate will be using their inner conviction with regards to the answers provided by the candidate, with regards to the level of the practical assignment that they have completed, with regards to their life experience and potential situation in their life experience that make us doubt on their integrity. So, of course, in any case, we cannot leave discretion out. But on the other hand, as I see it, maybe we should additionally, in order to limit some potential abuse on the part of HQCJ members, maybe we could introduce some mechanisms of inner control, inner examination of HQCJ members. Because some HQCJ members can be putting only high scores, while the others can put only low scores. So there shouldn't be any imbalance here. In addition, so that our reforms are a success, we shouldn't be thinking that everything depends on the members of HQCJ, because the Secretariat of HQCJ is the one entrusted with the organizational support of all the procedures. That is why a lot depends on the people who directly do a lot of things. So they shouldn't be revealing any confidential information that can be used by some of the candidates or judges during qualification assessment. So I suggest that we introduce the mechanisms to control both HQCJ members and the members of the Secretariat.
All right. Thank you for your answer, Mr. Bodnaruk. I want to move into another area, if I may. I have been concerned with the relationship in the past that exists or existed between the High Qualification Commission and the Public Integrity Council. The law, of course, prescribes the role and involvement of the Public Integrity Council in very brief, I might add, and succinct ways. And it has left to these parties the opportunity and obligation, I would say, to define their relationship. That relationship has not worked very well, at least very satisfactorily, from the perspective of the Public Integrity Council and its supporters, including the civil society organizations. Now, what suggestions would you have with respect to improving the relationship between these two entities that have the same goal in mind, on the one hand, and secondly, what practical suggestions would you have to improve the relationship, and secondly, to improve the degree of reliance that the HQCJ may give to the PIC opinions and advice?
Thanks a lot for this question, Todd. This is a really relevant question. Well, the relationship between a previous HQCJ and the Public Council of Integrity was quite tense, if I can use this word. But the thing is that the information provided by the Public Integrity Council to the HQCJ about the judges or candidate judges during qualification assessment quite often the information was not taken into account by HQCJ. Any negative opinions were overcome by HQCJ without any justification. So the society was right to ask these questions. Well, the Public Integrity Council is telling us that this candidate is not really ethical and there are questions and doubts about their competence, and HQCJ is overcoming these negative opinions without any explanations. So the first thing we need to do in the practical sense to enhance trust both in the judiciary and in HQCJ is the necessity for every negative opinion, should the HQCJ disagree with those negative opinions, HQCJ should motivate their decision. They should state it clearly that during discussions, during inspection of the information, they have not found any proof to those facts. So the motivation of the decisions of HQCJ is indeed important. This will enhance trust in HQCJ. It will improve the relationship between HQCJ and Public Integrity Council, because as you've mentioned, the two bodies work for the same end goal.
Yes, thank you for your suggestion in that respect, Mr. Bodnaruk. I hope the rest of the candidates see the situation in much the same way as you do. That certainly is a beginning. There are other opportunities as well, I suspect. My last question is this. I think we are all aware of the extraordinary challenges that the HQCJ and its members will have. There are almost 4 years now that there has been no HQCJ, and the volume of work has been building up. We have well over 2,000 vacancies to be filled, well over 2,000 requalifications that have to be performed. There are positions vacant in the appeal courts, which under the law are required to be filled, and of course there is no one and no process to fill them. I suspect that everyone is aware that there will have to be some very considerable changes in the process and procedures of the HQCJ and therefore its members to attempt to efficiently, more efficiently, handle these extraordinarily challenging work conditions. You've already made one suggestion, and I don't think that really comes to grips with it. The issue is not the number of candidates that are available to fill these positions. The issue is, how does the HQCJ go about the work of assessing and vetting the candidates that are available to fill these positions and that are waiting, for example, to be requalified. What suggestions do you have to cope with these challenges?
Thanks a lot for this question, because I do have some suggestions. As far as the vacancies are concerned, I think that we should indeed look back on the past. 3 years have passed, and some of the candidates have participated in the competition, and they stopped at different stages in the competition. And over the past 3 years, the information about the requirements, about the intentions of those candidates to even go on with their participation in the competition may have changed. So first of all, we need to update the lists. We need to invite or give the candidates an opportunity to confirm their intention to proceed with the competition. We need to inform them about those important changes that have taken place. So, updating, actualizing. Number 2. Ukraine is currently in a very complicated financial situation caused by war. This is obvious. We have a huge deficit in our budget, and we are extremely dependent on our international partners and outside loans. That is why it's the function of the High Council of Justice and the State Judicial Administration to look into our financial potential. So how many judges, how many assistant judges and secretaries can we have in the upcoming year, this year, let's say? So what's the actual demand, and what is our potential to fund this number of judges, assistants, etc.? So the thing that requires the least funding is what I'm suggesting, because currently we are having reserves of candidates. Some of these people have already been appointed by President Zelensky, and they are already administering justice, and some of them are still in the reserve. And I believe that these candidates should be the first one to participate in the competition to fill the vacancies. I think it will be the most speedy measure that doesn't require any additional, at least any significant funding. And we know that according to the Council of Judges, there are some 400 judges whose mandate has been terminated because of the expiration of the 5-term period. And these people are a burden to the budget because they still receive their salary, but they don't administer justice. And I think we need to invite these people to qualification assessment and give them the opportunity to prove their level of professional competence and professional ethics, so that they can get back to their workplaces and take over some of the workload from their colleagues. So with regards to the procedures, you also mentioned that the procedures should be improved. While indeed the intermediary provisions of the law mention that the newly selected HQCJ should complete the qualification procedures, but according to those procedures that were set out for the candidates at the beginning, I believe that for the new members of HQCJ, there should be enough mandate to complete the assessment even under the previously existing conditions. But we hear it from the society and from the civil society organizations that the previous HQCJ was doing quite a superficial assessment And we can see some broadcasts on YouTube. We can see how the interviews took place, and we can see that those interviews were not too careful, not too deep. I think that the future HQCJ can use the same procedure to assess those judges who have not yet completed their qualification assessment, but they can be more careful and detailed about the assessment. They can go deeper into the documents, into the statements received from civil society organizations. So the future HQCJ should be more transparent and fair. Thank you.
Thank you.
Thank you. That's my final question. Thank you, reporter.
Дякую. Ну, сподіваюся, що тепер дійшла і до мене черга.
Thank you.
Друге коло питань.
Now we are starting round 2 of our questions. So Yuri, my next question is the following. We can see that you can give us long and detailed answers, but unfortunately we have some time limits. We have only 20 minutes left.
Як ви вважаєте,
So my question is as follows. How do you think during the next selection of judges by the High Qualifications Commission of Judges, is it important that we apply
доброчесності
the presumption of integrity or the presumption of non-integrity to our candidates? Should we believe that all the candidates have integrity, or vice versa? Should we believe that they don't have the integrity and they should prove us wrong? Thank you, Yevhen, for this question. Of course, the Commission should start with the presumption of integrity. And the Commission has all the tools necessary to check the integrity as part of a special review, as part of the review of tax declarations by NACP, as part of checking family ties. Of course, we will be receiving information from civil society organizations, and should there be any negative stories, any public things that may cause doubt, of course we'll have to check them, but we should primarily start with presumption of integrity. Thank you. My next question. Of course, you see
осіб, яких ми добрали для проведення співбесіди,
that the people who have been selected, you know who the people that we have selected for the interviews are, and you know who are the participants of stage 2.
вас особисто.
If it's not about you personally,
Осіб із зазначеного
could you name
матеріалу
3 people out of that list
не як член
that
комісії,
you personally, not as a commission member, but as a lawyer, would like to see as part of the future HQCJ? Thanks a lot for this question. It's a very interesting question, I have to tell you. I cannot give you 3 surnames, but I can give you at least 1. And this is candidate whose public speeches, papers, and biography I became aware of when getting ready for the interviews, and this is Roman Kuybida. I believe that he is quite a decent candidate to be a member of this body. Of course, I know Mykola Hovanyuk, our renowned academic. As far as the judges are concerned, I cannot tell you anything because I don't know them. But I think this is my answer to your question. Thank you for your answer. And finally,
почесним ректором, якщо я не помиляюся,
the honorable rector, at least the former rector and MP of the Odessa Law Academy, was Mr. Kivalov.
особисто.
Could you please tell us,
Політичні або персональні
do you have any political or personal ties to this person? At this moment, I have no personal connections to him. When I was working at the academy, he was the head of the department that I was working at, and then a different professor was appointed. I don't have any political ties with him because it's known that Mr. Kivalo is a member of a political party. I've never been a member of that party, and I've never been a member of any political party for that member. So there are no ties between us. We have no relationship. Thank you.
Well, thank you. I think we come to the end of our interview. I have only one question, which is, let's say, a more general question. Yesterday I was reading, let's say, a bit of legal publications. There was a publication from the EU regarding the fight of corruption, and it's a report of hundreds and hundreds of pages which gives the state of corruption, fighting corruption within the EU. And what the document shows is that that's also within the EU the fight against corruption is not perfect, and that the reason for that is that sometimes countries are hesitating to investigate and especially enforce against high-placed individuals' allegations of corruption. And again, in this report, it's made very clear that if you want to fight corruption, you want to raise the view of the view how people in the country view the activity of the state, it's important that there is a zero tolerance on corrupt behavior. Secondly, that it should be investigated, and third, it should be enforced. And also, it must be seen that the people in high places who have done things that they should have been done will fall down from the high position they have had, and they cannot take part any longer within society for a very long time. Only in that way, according to this report, you will make sure that in the future the country will be cleaned of corruption and influence and the poverty resulting of that. If you want, of course, have a look on Google. You can find the report. You can see it. My question to you is, when I listen time after time, the candidates, and we have a few now, what I listen and when you discussed the level of trust, I hear many, many words about rules and regulations and citations of law, etc. But I always say law is only the hammer and the nail of the guy who makes a cupboard, the handsman. Law is only a tool, it's not what it's all about. And you should do something with this tool in order to come to a result. So my question to you is, taking off all the formality, if you would have all the power in the world, what would you do to increase the trust of the judiciary in Ukraine?
Well, of course, as I've mentioned in my motivational letter, it's quite obvious that the decisive role in this process will be played by the High Council of Justice and High Qualification Commission of Judges. And these bodies should be made of people of integrity. But on the other hand, we need to understand that we already have some judges who have been administering justice for quite some time. And they have gotten used to some corrupt practices, and they are unwilling to be part of the cleansing process. They don't want to vacate their positions for the people of integrity to replace them. So regardless of the reforms that we will implement, the process will be gradual. It will be hard to fight against them. So you told me that if I had any powers in the world, what could I do? But it's my conviction that corruption in the judiciary and in the government in general is connected to the so-called economic foundation. So in parallel, we need to improve economic processes, we need to improve the welfare of the citizens, we need to give freedom to entrepreneurs, we don't need to exert pressure on small businesses. And if this environment is cultivated under healthy conditions, then gradually the realization of the citizens will change. It will change for the judges as well, and the system will cleanse itself.
Thank you very much for the interview. Thank you for your time. And, well, I think this is the end of the interview. Okay. No questions. Mr. Chairman.
Пане Юрію, до 2 хвилин.
Jury, we are now giving you up to 2 minutes
Завершальне слово на
for your final remarks.
хочете
Perhaps
підкреслити свою
you'd like to draw attention to some of the statements that you've already made. Perhaps you'd like to add something. You're welcome. The Commission is giving you the opportunity to finish your interviews. Up to 2 minutes, the most important things. You're welcome. Thank you, Mr. Mishchenko. Well, there were more specific proposals that I planned to introduce to you today, but of course, they're not fit for the concluding remarks. Well, first of all, I would like to wish all of us for peace and victory. I'd like to thank the armed forces of Ukraine. We are grateful for everything that they are doing for our country. I wish the best of luck to the commissioners and a successful end to this competition. And we are thanking you.
на цьому інтерв'ю завершено.
So that is the end of the interview. Thank you for the participation, Yuri. Goodbye. Goodbye. Thank you.